Student Member Hernandez, please step forward. Morning.
All right.
You go ahead, Mr. Chairman.
Thank you, Mr. Chair. Mr. Chair and members, good morning. And let me introduce, this bill will ensure the waivers of important employment. This bill, AB 465, will ensure that waivers of important employment rights and procedures arising under California law are made voluntarily and with the consent of the employee. Many of us are aware of the vast proliferation of waivers and arbitration clauses contained in consumer contracts. This problem is even more egregious in the employment context through the use of mandatory or forced arbitration clauses. More and more employers often require these clauses to be signed as a condition of employment. Often they are buried in the fine print of the massive amounts of documents employees are forced to sign in order to obtain a job. A recent Wall Street Journal article reported that in 2014, 43% of employers required workers to sign these agreements. There is nothing voluntary about these agreements when they are forced upon the workers on a take it or leave it basis. Let's not fool ourselves. There is not an equal bargaining power between an employer and a worker who is desperate for a job to support themselves and their families. Especially in today's still struggling economy, workers are desperate for a job, any job, and will almost always sign any document that is put in front of them as a condition for employment. This system is entirely unfair because the employer generally selects the arbitrator who has a financial incentive to rule in the employer's favor. This bill attempts to bring some balance to the equation by simply ensuring that these agreements are truly voluntary. The bill does the following. It ensures that these agreements will not be required as a condition for employment. It prohibits an employer from discriminating or retaliating against any employee who refuses to sign such an agreement. And lastly, it ensures that such agreements are knowing, they're voluntary, and they're in writing. This bill is patterned after legislation authored last year by Assemblymember Shirley Weber, whose bill was signed into law by Governor Brown. That bill imposed similar requirements related to waivers of civil rights claims. No worker should be forced to choose between a job and giving up core labor rights and procedures. All of the important bills we work so hard to pass here in the California legislature would be meaningless if one day workers are forced, on day one, if workers are forced to sign away enforcement of those rights. That's exactly what is happening in California today, much like it is in most parts of the country. And that's why we're asking you to please help us in supporting a bill to protect our working folks up and down our state. I respectfully ask for your vote.
Thank you.
Mr. Chair and members, Caitlin Vega for the California Labor Federation. We are the sponsors of this measure along with the Teamsters Union. This issue of these kinds of waiver of rights agreements came to our attention a couple of years ago. We started hearing from our unions and from worker centers and legal aid advocates that increasingly when they were talking to workers who were experiencing wage theft, they would find, that they hadn't been paid for all the hours, they were doing overtime off the clock, they weren't getting meal periods, and they would start to try to help these workers only to discover they had signed an agreement upon hire and as a condition of employment. In almost every case, an agreement the worker did not even know that they had signed, and that agreement had waived the worker's ability to take a claim to the state labor commissioner or to take a claim to court to do any sort of a collective action. Instead, based on that agreement, this worker was tied to the employer's arbitration process. So the employer contracts with a set of arbitrators or with a company to provide arbitrators, and that worker has no other option to take any labor-related claim anywhere but to the employer's arbitrator. Now, this is something, so we started to look into this issue. We couldn't believe, honestly, that workers even could waive their right to go to the labor commissioner, and we found that the courts have said those agreements are enforceable, and there's nothing we can do to limit the inclusion of a waiver of the right to go to state agencies in these kinds of agreements. These agreements have increased dramatically over the last couple of years. Since 2011, they went from 17% of employers saying they use these agreements to 43%. So it's a dramatic increase. And in our view, that's because these insulate employers from most of the consequences of serious labor law violations. The harm from these kinds of agreements goes beyond the impact on an individual worker. Obviously, no worker should be required to give up such core protections when it's not knowing or voluntary. But beyond that, this takes away the ability of the state labor commissioner to even know what is happening in these work sites. These arbitration agreements are private, they are individual, they do not provide a forum for the state labor commissioner or for anyone else to know what is happening and to try to find a more systemic solution, or to say, wow, there's a lot of violations coming out of this one site or this one employer, maybe we should consider a more efficient enforcement plan than just each individual worker having to take their claim separately to an arbitrator. In addition, low-wage workers are highly unlikely to find counsel for an arbitration process. In almost every case, they are going to be trying to navigate that process alone because there are no real incentives for lawyers to take those cases. And in most cases, what we're finding is what it means is not that the worker's claim is stuck in arbitration, but that workers don't even bother to file a claim. They're not able to access the one free option, which is the state labor commissioner, the thing that usually legal aid advocates or unions are able to help workers with and help them navigate through. Knowing that they're stuck in that process in most cases discourages them from even taking a claim forward. So we recognize that this was a very serious threat to all of the laws that we work to enforce and to pass in California. In fact, just last year we passed a bill, AB 1897, which was intended to go after employers who use third-party contractors to get away with labor law abuses. Now we've heard repeated examples of temporary staffing agencies using these kinds of agreements to protect themselves and the users from the impact of AB 1897. So we have struggled to come up with a solution that we think will be effective and is also steers clear of federal preemption. The courts have taken a fairly pro-arbitration perspective on these cases, and so we stuck with the model used by Dr. Weber in the bill last year, which really focuses on two pieces. Contract formation, which is within the state's ability to regulate. We say that these contracts, like all adhesion contracts, have to be knowing and voluntary, cannot be entered into because the worker was coerced. And in our view, being told you only get this job if you sign away your rights is inherently coercive. So this bill says cannot be a condition of employment. You cannot threaten or retaliate against a worker because they don't want to waive these rights. That's all it does. It doesn't ban the use of these arbitration agreements. We understand in many cases they will continue to be used. All it does is try to make sure that this happens in a fair way and that the worker has some sense of what they're signing and that it's done voluntarily. And with that, I want to just introduce Rajan Nanavati, who's here to share his story.
Hi, how are you? Hi, how's it going? Good morning, guys. So I was hired through a staffing agency in the Bay Area for a high-tech company, and prior to starting that job, I was rushed through multiple screens of onboarding paperwork such as W-4s, going through that whole process, and at no part of any of the screens there was any opt-out option at all. So during the time that I was working as a dispatcher at this high-tech Bay Area company, I was working 10 to 16-hour days, no lunches, no breaks, none of that sort. And several times I even had to bring my laptop into the restroom and continue working. That's just how it worked at that company. And so at that point, I mentioned to the to HR, and I said, hey, I'm an hourly employee. I should get rest breaks or meal periods or some sort. And they turned to me, and HR for the staffing agency said, well, we'll look into it. We'll see what we can do for you guys. And I kept on continuously, bringing up the issue, just talking to them and say, hey, is there any way we can work something out of that sort? And they refused to even, talk to me about that issue. Then one day I was brought into to the office, and when I was brought in, they actually terminated me, and they said that I wasn't suitable for the project, that, I had to go. The staffing agent said, we don't see you suitable, you have to go. And not only did they terminate me, they still have my final paycheck. They still haven't paid me, and it's been over probably good 6 months. They still haven't paid me my final paycheck. And then when I brought up the claims, I found out that through my attorney that they said that I actually signed an arbitration clause, and I had no idea, and they didn't even tell me or even allow me to opt out of that. So I feel that what they did to me was unfair. So I'm in support of this bill.
Thank you. Thank you for sharing.
Yes.
Any other witnesses in support? If you don't mind, having some other folks can testify.
Jacqueline Sarin on behalf of the Consumer Attorneys of California. We're in strong support. Thank you.
Jeremy Smith on behalf of the State Building Trades, also in support.
Thank you, Mr. Chair. Members, Megan Brightwell on behalf of the California Professional Firefighters in support.
Scott Bernstein for the California Employment Lawyers Association. We are in support. I've been handling arbitration cases since 1992, and I'm available to answer any questions about the reality of arbitration that anyone may have.
Great, thank you.
Mr. Chair, member Kevin Baker for the American Civil Liberties Union, and also in support. These agreements involve not only the waiver of labor code violations, but also constitutional rights. We ask for your support.
Okay, great. Other witnesses, let's go ahead and start and have the opposition step forward.
Hi. Good. How are you? Yes, Senator Jackson, the California Chamber of Commerce, in opposition to AB 465. I just kind of wanted to address some of the points that were raised by the proponents and in the analysis. The first issue was that all they want to do with regard, well, not what all they want to do, but one of the issues is to make sure that these agreements are knowing and voluntary, that they're entered into knowing and voluntary. The requirement that a contract be entered into knowing and voluntary is applicable to all contracts, including arbitration agreements. That's the current law today. You have to have mutual free consent by both parties entering into a contract to make it enforceable. And if it isn't, then you can revoke it now. So the statement that we want to make sure these agreements are knowing and voluntary is already existing law, and if that is what the bill does, we are happy to have that specified, that an arbitration agreement must be knowing and voluntary. But there is a level of responsibility on parties that the law imposes to actually read a document that you sign. So the fact that you sign a document and you may not have reviewed the document, the law does impose some responsibility for you actually to review that. Now, if the document is in a language that you don't understand or that is not your primary language, there have been cases where a contract has been revoked because it's not knowing and voluntary. So that is already the law. With regards to an adhesion contract, yes, the employment arbitration agreements are an adhesion contract, meaning that it is essentially you don't have equal bargaining power by both sides, and it is an agreement that the employer offers to the employee and they don't have an opportunity to negotiate. That's no different than a lot of the consumer arbitration agreements that you have with regards to the sale of products all across our state. You don't have parties that have equal bargaining power and they're required to take the terms of the contract and can't negotiate it. With respect to employment arbitration agreements, the Supreme Court of California has come down and said that because employees are required to enter into these agreements and they don't have equal bargaining power, we are going to make sure that those agreements have certain provisions included in them to make sure that they're fair for both parties. That was the Armendariz case, and it specifies that the agreement must require a neutral arbitrator. If there is an arbitrator that is not impartial, then they've already in violation of the California Supreme Court decision. It has to provide for discovery. It has to provide the opportunity for a review of the arbitration award, and the employee cannot be required to pay any cost in arbitration that they would not otherwise be required to pay if they went to court. So those are the mandatory provisions that must be included. Whoops, I forgot one issue. You cannot have a waiver of any legal right. So the proponents kept saying that these arbitration agreements require employees to waive substantive rights that they have available, and that is not the case. You cannot do it, or the arbitration agreements are deemed unenforceable, and the courts have struck them down in cases in which arbitration agreements have tried to either limit the statute of limitations under which to bring a labor and employment claim, or the remedies available for a labor or an employment claim. So the arbitration agreements have to allow them to pursue substantive rights. with regards to the other issue on the repeat player, or that there's some financial incentive for employers to go to arbitration, I've heard that come up, that there's an unfair advantage for employers and employees. As I just mentioned, the Armendariz case requires employers to essentially pay for the arbitration costs. So I think it's an unfair allegation to say that employers pay the arbitrator, so they must have some unfair advantage, when the law actually requires the employers to pay for the arbitration. I can say, although I haven't asked my members, that they would be open to sharing the costs of arbitration to avoid that unfair advantage from the financial incentive perspective. But right now, under the law, we're required to pay for arbitration. The companies generally hire an arbitration company. They don't contract with a specific arbitrator. And the arbitration company will provide a list of arbitrators for both sides to pick from, and they basically get peremptory challenges where both sides can sit there and strike whatever arbitrators they don't want. The arbitrators themselves are required to go through a very extensive list of disclosures before the arbitration. So they have to disclose any relationship they've had with any of the parties involved, with regards to any of the attorneys involved, in any type of professional or personal relationship. And those parties involved in the arbitration will know if the arbitrator has had any prior cases with the employer or the attorney representing the employer, and the outcome of those cases. So the employees are fully aware up front of any relationship or prior cases that the arbitrator has had with the employer. So from our perspective, there's not a repeat player issue, and there's studies out there that show that employees fare better in arbitration, if not the same. And if there was a repeat player, you wouldn't have that type of success rate. The last thing I wanted to mention is regards to the comment that employees are not allowed to pursue a collective action. And that is accurate as well. That a lot of these arbitration agreements have class action waivers, but that does not mean that the employees don't have a remedy. The arbitration obviously provides them a remedy. You can't limit the remedies available. And as I just mentioned, their studies show that they are successful in arbitration with the same amount of awards as if they go to court. They just don't get to bring it in a class action. And we've seen in labor and employment especially that in the class action procedures, it's not necessarily the employees at the end of the day that benefit. They get very limited amounts in a class action award, and the attorneys and the attorneys' fees are the substantial part of those class actions. So from our perspective, they're not going to fare any worse in arbitration than they do with regards to the collective action. And finally, with the labor commissioner, there's nothing that an arbitration agreement can do to limit a state agency's opportunity to investigate and pursue a claim. So the arbitration agreements themselves cannot prohibit the labor commissioner from coming in and investigating a work site. You can't stop an agency from doing it through the labor agreement or through an arbitration agreement. So that is also somewhat ambiguous on that issue, and I just wanted to clear it up. For those reasons, we're opposed.
Mr. Chair, members, Chris McKaylee on behalf of the Civil Justice Association of California. We're troubled by the comments by the proponents and the author and the two findings in the proposed bill that these agreements are based on coercion. There is no force or threat, which is generally the definition of coercion. As Ms. Barrera indicated, the courts are looking for protections. The Code of Civil Procedure specifically says that arbitration agreements are subject to review on the same grounds as general contract revocation. Specifically, court review is provided. The author and proponents have repeatedly claimed that these provisions waivers are contained in the fine print, hidden in employee handbooks, et cetera. For non-English speaking individuals, there isn't any translation, et cetera. There was most recently a March 23rd of this year California Court of Appeal decision for the 2nd District, in which both of those were specifically determined to be basis for throwing out the arbitration agreement. This was an individual who was Spanish speaking. The agreement was in English. There was no translation. There was no explanation of the waiver itself. And the Court of Appeal did not enforce the arbitration agreement. As we raised in the Assembly Policy Committee, the sponsors have talked a lot about low-wage workers. Frankly, I'm not sure how they would benefit where arbitration is generally a more efficient and a much quicker process than the civil court system. So if we're trying to protect low-wage workers subject to wage theft, I don't know why we're shoving them into the civil court system. This committee and this House has already passed Senate Bill 588 by the pro tem of the Senate, which specifically attempts to combat wage theft, gives additional powers to the Labor Commissioner, and other abilities to specifically combat wage theft. Again, we don't know how moving these cases out of arbitration will help in that regard. The author and sponsors indicate that this is a mere extension of AB 2617. The bill by by Assemblymember Weber is specific to hate crimes under the Unruh Civil Rights Act. It is very narrowly tailored. This bill, of course, would apply to all labor code violations, Title VII, discrimination cases, etc. And we argued, unsuccessfully granted, but we still believe that 2617 is in fact federally preempted. Unfortunately, that is easily a decade away from determination. As your consultants in particular are aware, it took the California Supreme Court 10 years to decide what the meaning of provide is in terms of wage and hour breaks. And during that time, there is a $10,000 civil penalty to which employers could be subject, which is deeply troubling for small employers. And lastly, I think that this bill would send a very strong but negative message nationwide. And finally, I find it a little ironic that even consumer attorneys utilize arbitration in their fee agreements, and even on occasion we find collective bargaining agreements negotiated by public sector unions include binding arbitration provisions as well. Thank you.
Good morning, Mr. Chair and members of the committee. Javier Gonzalez on behalf of the California Restaurant Association in opposition.
Dane Hutchings of the California Grocers Association in opposition.
Mike Belote for the California Employment Law Council, opposed. Thank you.
Matthew Allen, Western Growers Association, strongly opposed.
Judy Hughes of the California League of Food Processors, strongly opposed.
Julie Broyles on behalf of Associated Builders and Contractors of California, also in opposition.
Nick Camerata on behalf of the California Building Industry Association. As an at-will employee who has signed an arbitration agreement, we are opposed.
Dave Melton, California Association of Realtors, and we are opposed for all the reasons stated.
Brian Little with the California Farm Bureau Federation in opposition.
Nicole Rice, California Manufacturers and Technology Association, also opposed.
Tim Schmelzer, Wine Institute, also in opposition.
Mr. Chair, members, Barry Broad on behalf of the Teamsters. I apologize. I was on a conference call and I missed the proponents. I just want to say we're co-sponsors of the bill and very strongly in favor of it. Thank you.
Great. Thank you.
Good morning. Braden Obrowski on behalf of the California Association for Health Services at Home in opposition. Thank you.
Matthew Hargrove with the California Business Properties Association in strong opposition.
Richard Markison on behalf of Air Conditioning Trade Association and Western Electrical Contractors in opposition.
Great. Thank you. Any other opposition? Seeing none, we're going to go ahead and open up for comments from our senators. We'll start with Senator Jackson.
Well, thank you so much. You know, I'm a recovering lawyer and take some bit of umbrage when people accuse lawyers of having the audacity to go into court to try to protect or exercise their clients' rights. And so I would like the gentleman who does a lot of this kind of law to step forward. And I have nothing but the highest regard for our colleague from the chamber who can still argue her position without looking at notes. And I'm always very impressed by that and her articulateness. I just happen in this case to think that the arguments, while theoretically sound quite good, in practice that's just not the way this all works, and that's why I wanted to ask the gentleman who practices this kind of law. I know that you did hear the arguments that were presented, and I'd like you to share with us what your experience is as the attorney representing people like that young man who ended up having to work while taking a restroom break and still 6 months later not getting his last check. Could you share with us a little bit about your experience and the type of client you represent and the type of employer and situation that you generally experience While we know that the contracts are supposed to be knowing and voluntary, when you have been out of work for several months and you get a job offer handed to you and you say, what is this? And they say, well, that's just standard procedure, sign the contract. I know as a lawyer, sometimes reading some of these employment contracts, you need a lawyer to understand them, and that they are not easily understood. But you do sign them because you assume that you're going to have some protections if they go back on what the expectations are, or if they violate existing labor laws, if they don't pay you as they're supposed to, if you don't get the kinds of breaks that you're supposed to get, all the protections that we've worked so hard to create here, both for the worker and the employer. And yet when the playing field suddenly it becomes unlevel, I mean, and that's really the politest way I can say it. There's an extraordinarily unlevel playing field out there today. I feel the same way, frankly, with when you go to see a doctor and you have to waive your right to sue, and you have to agree to mandatory binding arbitration through AAA or something of that sort. I mean, what's your choice? You've waited 2 months for your doctor's appointment. You feel lousy. You're in their office. You finally have your appointment, and you're told take it or leave it. That to me is not an equally bargained agreement. But here we are with the labor situation. So could you just give us a little bit of your expertise? How many years have you been practicing in this area?